Welcome to Rapid Fire Wednesdays, Q&A for corporate immigration professionals. I'm Kimberley Robidoux, a partner in our San Diego office, and I'm joined as always by Miki Matrician, the co-managing partner of our Boston office. How are you doing this week, Miki?
I'm well, Kim. How are you?
I'm doing good, thanks. Can't believe it's already towards the end of July. And with that, there's a lot of stuff for us to discuss. This week, we're going to talk about some regulatory and legislative updates that have been proposed, as well as an update on some of the TPS programs. The first update is that USCIS announced that the H-1B cap for fiscal year 2026 has been reached. So USCIS stated that they have received sufficient H-1B petitions to meet their 65,000 regular cap, as well as the 20,000 master's cap. So unfortunately, that means no second round for the H-1B registration lottery this year. And then moving on to the legislative and regulatory front, information has been provided that the administration is introducing a regulation to change the H-1B cap registration process. In addition, Representative Pramila Jayapal, who's a Democrat from Washington state, has introduced legislation that would bar U.S. Immigration and Customs Enforcement from using federal funds to detain or deport U.S. citizens. And then we also have a bipartisan group of legislators in Congress that have reintroduced the Dignity Act of 2025. Right. So that's not all. We're also going to discuss a little bit more about each one of these and how they may impact immigration and global mobility programs. So I did mention that the H-1B cap has been reached for fiscal year 2026, which means that there will not be another lottery until March of 2026. So, related to that, last week the administration sent from USCIS to the Office of Information and Regulatory Affairs a proposed rule for review that is called Weighted Selection Process for Registrants and Petitioners Seeking to File CAP Subject H-1B Petitions. So, this regulation has not yet been published in the Federal Register, and there is not much available to the public at this time. Regardless, and given what we know from prior Trump administrations, Mickey, can you tell us what this regulation is about and what we know at this time?
Sure. So in 2021, the draft regulations drew more than 1,000 public comments. And a lot of commenters argued that the regulation would drastically reduce the number of available H-1B workers. And this version of the proposed regulation, which is based on the similar proposed regulation from Trump 1.0, will require cap subject employers during the H-1B cap lottery registration process to provide the SOC code, which is the occupational code, the offered salary, and the worksite location of the position to be offered in the H-1B petition. And then the randomized lottery would be conducted to provide 4 chances for a level 4 wage, and then 3 chances for a level 3 wage, 2 chances for level 2 wage, and a single chance in the registration lottery for a level 1 wage. So, this proposed rule would revise the H-1B lottery through wage prioritization, and that will definitely have a direct and negative impact to US employers. And specifically, this would impact companies that are subject to H-1 numerical caps. And so the impact would be on companies that hire international students that earn degrees in the US right after graduation, or professionals who are hired early in their career. It will also impact universities that want to enroll international students that want a chance to work in the US right after graduation and even after they've used post completion optional practical training in STEM OPT. So we anticipate many comments against this proposed regulation, as well as potential litigation, especially given that federal courts had previously blocked regulations to raise the H-1B prevailing wage floors and narrow the range of positions that qualify.
Yeah, so Mickey, that would be a significant change to the H-1B program for sure and have a tremendous impact. So moving on from H-1Bs, let's go on to a different topic. And could you update us on the proposed Dignity Act of 2025, Mickey?
Yeah, the Dignity Act of 2025 has been introduced by a bipartisan group of lawmakers. And it's a really broad immigration proposal that offers a structured path to legal status for undocumented immigrants, while at the same time transforming border security, asylum, and legal immigration. So, this is a really packed bill, and the sponsors of the bill said that the goals of the bill include ending illegal immigration, providing a legal pathway for long term undocumented immigrants, protecting dreamers, reforming the asylum system, securing the border using technology and infrastructure, investing in US workers through training and apprenticeships, and modernizing the legal immigration system, all without using taxpayer dollars. So it's still a bill and not yet law. But if it became law, the provisions could significantly impact corporate mobility programs and international talent planning. Let's discuss the key implications for global mobility and human resources. Legal pathways for dreamers and the undocumented provision. Specifically, under the Dignity Program, undocumented immigrants in the United States since December 31st of 2020 would be allowed to apply for a 7-year legal status program with work authorization after passing background checks and paying a restitution fee. And this wouldn't be a path to citizenship or permanent resident status, but it would instead provide temporary status that would be renewed every 7 years. And the potential impact could be an increase in the pool of legally authorized workers for certain industries like agriculture, manufacturing, and services. And under this program, Dreamers would get conditional permanent residence that's valid for 10 years. And they'd have the opportunity to apply for lawful permanent resident status and eventually citizenship. And this is for people who arrived in the US under the age of 18 years by January 2021. And then the bill also includes STEM talent access and employment based reforms, including a fast track to permanent resident status for US trained STEM PhDs. There's an annual cap on the per country visas, basically US green cards issued per fiscal year. And this provision would increase that cap from 7% to 15%, as well as exclude the counting of dependent family members against the cap. And then it also contains a $20,000 fee to expedite applications that have been waiting for a long time for permanent resident processes to be approved. So, if these provisions were to be enacted, it really would ease the pressure on quota backlogs and especially for Indian and Chinese nationals, and would increase flexibility for employers to retain critical talent. The bill also provides for optional practical training for international students. Specifically, F1 OPT participants would need to pay into Social Security and Medicare, which would result in a higher cost of employment for OPT students. A benefit to F1 visa holders, though, is that it would permit dual intent, which helps students who might have difficulty showing that they plan to return to their home country after their studies. Um, Kim, can you walk us through the bill provisions that deal with worksite compliance matters?
Yeah, sure. So the proposed Dignity Act includes a provision for nationwide e-verify mandate, and this would mean mandatory use of e-verify for all U.S. employers. This type of requirement would result in human resources and global mobility teams to be able to ensure systems and training are updated nationwide for mandatory e-verify, as opposed to just in current states that mandate e-verify. It also would have a direct impact on the onboarding processes, given that there would have to be a lot of training for the E-Verify program and administration. So, this Dignity Act also calls for harsher penalties for violations, including the hiring of unauthorized workers. And those penalties could result in increased legal exposure for noncompliance by that particular company. And the act also proposes a 1% wage levy on undocumented workers in the Dignity program that Mickey, you were just talking about, as well as a $7,000 restitution fee per participant, which would fund job training for US workers. Essentially, it's a legislative push to tie legalization to workforce development. And then, as you mentioned, Mickey, while the Dignity Act of 2025 has bipartisan support, it's not yet law. So, global mobility professionals and HR should monitor developments and begin evaluating potential policy and procedural adjustments in the following areas to include employment verification, green card strategy, student hiring, as well as risk mitigation and compliance, specifically with work sites. And then we're going to move over a little bit more to another topic for today. Mickey, could you briefly tell us about Representative Jayapal's legislation?
Yeah, so there have been a lot of reports of a rise in wrongful immigration enforcement actions against U.S. citizens. And so as a result, Representative Jayapal introduced the bill entitled Stop ICE from Kidnapping U.S. Citizens Act last week in the House of Representatives. And that bill targets what Representative Jayapal calls a pattern of unconstitutional and deeply traumatic errors under the current administration's enforcement actions regarding immigration. And so, under the proposed legislation, ICE would be prohibited from using any federal funds to, number one, detain a U.S. citizen during civil immigration enforcement, or number two, transport a US citizen outside of the US on the premise of immigration law. So the bill is meant to address reported unlawful actions by ICE, such as failing to verify citizenship status before detention or ignoring documentation presented by the US citizen and their families to prove US citizenship. And Kim, last topic for this Rapid Fire Wednesday. I know that there have been some recent updates with temporary protected status, especially with all of the litigation. Can you tell us the latest?
Yeah, of course. So let's start first with Haiti. The U.S. District Court for the Eastern District of New York issued a final judgment in the litigation titled Haitian Evangelical Clergy Association versus Trump. This was issued last week. And that decision makes the effective date of any TPS termination and work authorization for Haiti no earlier than February 3rd of 2026. So there was been a lot of back and forth on that. So now it is effectively February 3rd as opposed to August, like we were concerned about. So that's for Haiti. And then for Afghanistan, a court of appeals issued an administrative stay on the termination of TPS for Afghans until July 21st of 2025. So TPS continues, and the A12 and C19 EADs that have a card expires date of November 20th, 2023 or May 20th of 2025. Those expiration dates are now valid through July 21st of 2025, and we'll see how litigation plays out for Afghanistan. So while the court issued the stay on July 14th, when Afghan TPS was set to expire, USCIS technically did not update their website until July 18th to confirm that the work authorization for Afghan TPS, along with the TPS designation, had been extended through July 21st. So there was a lot of confusion there. And then just a reminder on TPS for Cameroon is set to expire August 4th. And then finally, TPS for Honduras and Nicaragua are currently set to expire on September 8th. And so I guess with that, it wraps up this week's Rapid Fire Wednesday. We'll continue monitoring legislative, regulatory, and court developments, as well as agency guidance, and provide updates in future episodes as we hear of them. And as always, for all the latest updates to the immigration landscape, please follow WR Immigration on LinkedIn, as well as Mickey and my personal profiles for breaking updates and insights on all these immigration actions. And then we'll also transcribe each and every episode and share it through our weekly newsletter, which you can subscribe to. The link to subscribe can be found in the video description. So thanks for joining us, and we'll see you next time. Great to see you again, Mickey. Have a good one.
Thanks, Kim. Good to see you too.